All rise. Oh yay, oh yay, oh yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning. And welcome to something very unique. We're actually in court. Not sure I remember how to act, to be quite honest. But
Do our best.
Judge Goldin says we're going to do the best we can, which is absolutely correct. We certainly appreciate you being here this morning. Before we get into the actual formalities of what we need to discuss, I want to take just a moment of privilege for the court here on behalf of Judges Goldin, McGee, and myself. This morning in Knoxville, they're having the funeral of Judge Charles Susano. Judge Susano was a longtime member of this court. I used to joke with him that I think I came on the trial bench the year before he got appointed to the Court of Appeals, and that was a long time ago. That was about, I think he went on in 1994, perhaps. Judge Susano had a very storied legal career. He was a wonderful lawyer. There are lots of stories about him, and some of them are even true, about the times that he was a lawyer and involved in cases. And he was a fantastic appellate judge. We will miss him dearly. He was the chief judge of this court for several years. He was respected throughout the state of Tennessee by all members of the bar and the judiciary, and he will be missed. So if you don't mind, we're just going to take a moment of silence and just remember Judge Susano, and then we will begin court. Thank you. Now to the matters at hand. Again, welcome to the Court of Appeals. I look around the room and I see many experienced practitioners, so there is not any real need for me to go into the mechanics of what we are doing here. However, I feel constrained to say a couple of things. First of all, each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved or you wish to reserve rebuttal time, please request that from the court, and we'll make sure you get that. You may reserve up to 5 minutes of rebuttal time. The lighting system on the podium is very straightforward. There are 3 lights, green, yellow, and red. As long as the light's green, you got plenty of time. When the light turns yellow, you're running out of time, and when the light is red, you are out of time, and we ask that you please respect those time constraints. Before we get started, I want to be sure and introduce our panel. We have Judge Arnold Goldin from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Anything we need to take up before we get started?
Not to my knowledge.
You're the one who should know. You may call the first case.
Britton, Gage, Blackburn et al. Versus Mark A. McLean, M.D. et al.
Good morning.
It please the court, I'm Joe Bednarz Jr., and along with my father, Joe Bednarz Sr., we represent the plaintiff appellant, Britton Blackburn. If I could, I'd like to reserve 4 minutes for rebuttal.
Yes, sir.
This appeal involves a series of decisions by the trial court which were erroneous and highly prejudicial that resulted in summary judgment being granted to both defendants. In In each instance, the trial court applied incorrect legal standards or no standards at all, despite the fact that all of those standards are clearly set forth in Tennessee law. To give this case a little bit of perspective, we were on a fast track as far as healthcare liability cases go. The complaint was filed in January of 2016, and we were actually set for trial in April of 2018. In January of 2018, the defendants filed motions to amend the answer to alleged comparative fault allegations against Cody Blackburn for failing to seek earlier medical treatment. And the gist of their argument is that he thought he had indigestion the day before and should have sought medical treatment. Ironically, when he got to the hospital the next day, the doctors also thought he had indigestion at first and gave him a GI cocktail. But the defendants argued then, and they continue to argue now, that this motion to amend should have been granted because it complied with the scheduling order. That's not a reason to grant a motion to amend.
Let me ask you a question. On that, you filed Rule 26 interrogatories on, they had 7 experts, I think.
Yes, sir.
And you filed those, did you get responses to those interrogatories from their experts?
We did.
Did any of their experts opine that there was comparative fault?
Not at all. No fault against Cody Blackburn, no causation testimony, nothing.
So the first time this came up was when Dr. Allen's deposition was taken?
Yes, sir, and that was in response to a specific question. I mean, it wasn't really part of his opinion. And he said, I guess if you assume that he would have gotten all the same treatment the day before, then, I mean, the whole allegation is a delay in diagnosis and treatment. So assuming you start a day earlier, you get rid of the delay. But that was it.
Did he say that he probably would have survived if he had come in earlier?
It was qualified. He was responding to a direct question, and he said, I guess you would have to assume that they would have done this and would have done that. I mean, it was a very general type response to a question.
He did have an abnormal EKG on the way to the hospital?
He did.
All right. I was interested mainly on the interrogatory answers, whether there was any indication that there was an opinion about a comparative fault.
But you don't grant a motion to amend just because it complies with the scheduling order any more than you would a motion for summary judgment. We still have factors to consider, an analysis that needs to be made. That's what we didn't get in this case. We didn't get the analysis. The judge just granted it because it was filed within the time prescribed in the scheduling order. Under Tennessee law, had he applied those factors, I think they weigh heavily in favor of denying the motion. The case was set for trial. Discovery was completed. There was no expert proof at all regarding causation or any of the actions of Mr. Blackburn. The other factor is whether the party will be prejudiced. In this case, all of those factors were overwhelmingly in support of denying this motion. And when you talk about prejudice, later on when we had another motion, it's a motion to alter or amend, which I'll talk about in a minute, but the trial court found that Dr. McLean would be prejudiced if he granted my motion to substitute experts because of the delay, because of the continuance, and the fact we'd have to open up discovery. Well, the same thing happened to me here with this motion to amend. We got an 11-month continuance. The trial judge told me I could redepose the defense experts, and he allowed me to get an expert, and I'll get to that in a minute too. But we had the same prejudice that he found Dr. McLean was going to experience later.
What was the purpose of the continuance at that point in time?
When he granted the motion to amend, he told us he would grant a continuance if we wanted it. At that point, we really didn't want a continuance, so we told him we really needed to think about it. We went back and tried to figure out how all of this was going to play out. We decided we did need a continuance to get expert proof. I mean, a continuance without the experts didn't do us any good at all.
But the original scheduling order was still in place at this time?
All of the deadlines had expired.
Okay. Was this discussed with the trial court?
It was. We asked him to be allowed to bring in another expert. He said, you can bring in an expert to talk about the default of Cody Blackburn, but he can't talk about the standard of care. He can't talk about the fault of Dr. McLean. He can't talk about the fault of the hospital or the nurses. And he can't compare the fault of Cody Blackburn to the doctor and the nurses. So he allowed us to bring...
Was this your motion at this time when it was discussed, or was this discussed at the time the continuance was obtained?
This was in response to my motion for continuance and to be allowed to bring in an expert. So we're allowed to bring in an expert to talk about comparative fault, but he can't talk about the fault of anybody but Cody Blackburn, and he can't compare fault to anybody. There's really not a whole lot left he could talk about. So,
Did you still have Dr. Sobel at this point?
we did. Now, at the same time, they had filed a motion to compel the tax returns. And the relationship was strained a little bit because the court granted the motion. Dr. Sobel didn't want to provide the tax returns, but we talked him into it. He wasn't happy about it, but he did it. Once the protective order was lifted, they were produced under a stay, then the protective order was lifted. Those tax returns were shared with lawyers all over the country in cases in which he was testifying, and he really got angry, and that's when he refused to testify. So then we went back and asked that we be allowed to replace Dr. Sobel. We got an affidavit from Dr. William Lunders, provided a Rule 26 opinion to Dr. Lunders, and asked to substitute, and tried to keep his opinions essentially identical, as close as we could to Dr. Sobel, so there would be no prejudice. It would have been a very simple thing to take one deposition and we're ready for trial. And but it just didn't happen. But having granted the motion to amend, the court still had that opportunity to lessen the prejudicial effect to us if he had just let us bring in an expert. Case law is crystal clear. When you grant a motion to amend a complaint or an answer at or near trial, you have to give the other side a chance to a time to respond and an opportunity to respond. We got the time, but we didn't get the opportunity. The continuance by itself didn't do us any good. We'd have been better off going to trial as scheduled in April. We'd have still had Dr. Sobel at that time. So time alone didn't do anything for us. I guess I ought to mention quickly the motions for summary judgment. They argue that I waived that issue. I don't believe I did. I put the facts in the statement of facts. I simply ran out of space. In my argument, I incorporated those facts by reference. They're straightforward, they're clear-cut. The judge granted summary judgment on 17 standard of care criticisms the defendant argued wasn't supported by any causation testimony. They were things like failing to get an x-ray timely, failing to take an EKG timely, and they were all part of his ultimate opinion that the delay in care and treatment led to his death. But when we first went down, the trial court said, I've only got 2 pages of the affidavit. He actually had the whole thing, but they were somewhere different. So I went back and I said, no, you did have the whole thing, and here it is. He refused to consider the rest of the affidavit, said there's nothing new there, I'm not going to change my mind. He also refused to consider Dr. Sobel's deposition, or not deposition testimony, Rule 26 disclosure, and a detailed single-spaced 10-page report of all of his opinions that had been authenticated
Well, that was after he had already, everyone was aware that he had already determined he wasn't going to testify.
No, this was before. This one on the 17 grounds, this was before. There were some problems with Dr. Sobel, but I don't think he'd withdrawn completely at that time. I could be mistaken.
At the time of the summary judgment?
The first one, the
the
partial
first one.
summary judgment. The final summary judgment, that simply just would not have happened had it not been for all these other errors. If we'd been allowed to get an expert, do the things we had to do to prepare for trial, it just wouldn't have happened. So as far as the last one goes, that's more a result of the other errors than it is, you know, if we didn't have any experts, I guess he was justified in granting summary judgment. So that was more a result than an error. And I'm out of time, so unless you've got any questions, I guess I will have a seat.
Thank you. You still have your rebuttal time.
May it please the court, I'm Marty Phillips, and I represent the appellee, Dr. Mark McLean. Mr. Beakes and I have conferred. I would like to use 12 minutes of our time, and Mr. Beakes would like to use 3 minutes of our time, if that's acceptable to the court.
Fine.
Plaintiff has raised 5 issues in this appeal. 4 of them are discretionary rulings of the trial court subject to an abuse of discretion review. And on all 4 of those issues, the trial court acted well within its sound discretion. The other issue pertains to a motion for summary judgment and the granting of that motion for summary judgment, and that issue has been waived. So we would ask the court to determine that the motion for summary judgment was correctly granted, and then the court can pretermit the remaining issues in this appeal. Let me begin, if I may, by addressing the motion for summary judgment issue. As the court is well aware, Tennessee Rule of Appellate Procedure 27 has some requirements for briefs, and those include that the briefs set forth a reason why appellate relief is warranted, that it cite to authorities, and that it cite to the record as appropriate. And then, of course, on top of Rule 27, we have case law that addresses this issue, including the Tennessee Supreme Court's decision in the Snead case. And there's similar cases reaching the same conclusion, but Snead indicates that the failure to develop an argument in a brief or merely offering a skeletal argument in a brief results in a waiver of the issue. And we would respectfully submit that that's exactly what we have here with regard to the appellate's brief on the summary judgment issue. The brief does not comply with Rule 27 as it pertains to the summary judgment argument, nor does it comply with the Snead case and other similar cases. If one assesses the brief of the appellant on the summary judgment issue, one will find one paragraph on page 63 of the brief, the argument section of the brief, devoted to the summary judgment issue. And the plaintiff says, the appellant says, as has been repeated in argument today, because of space limitations, they can't really address the summary judgment issue. That's how it's dealt with in the brief. And unfortunately, that results in a waiver of the issue. So we think on that basis, the court can affirm the grant of the summary judgment motion. Even if, however, this court looks further and assesses the substantive ruling on summary judgment and moves beyond the waiver issue, we contend that the trial court correctly granted summary judgment to Dr. McLean. The trial court relied upon the Western Section's opinion in Anderson versus Hauser, a 2001 case involving very similar circumstances as the case at bar. That opinion was authored by then Judge Kirby. And the essence of the Anderson versus Hauser opinion is that at the summary judgment stage, if the plaintiff offers an affidavit of an expert who will not testify at trial, then summary judgment is appropriate because, as the court said, there is not presented a justiciable claim that warrants trial. And if you look at the trial court's order granting Dr. McLean's motion for summary judgment, he cited and discussed the Anderson case and its similarity to the circumstances that we had in our particular case. And in our particular case, at the time of the summary judgment hearing and at the time of the summary judgment ruling, it was undisputed, as the trial court's order delineates, that Dr. Sobel was not going to testify at trial.
Which summary judgment hearing are we talking about?
The last one.
The last one?
Yes, sir. That was the full summary judgment. What you and Mr. Bednarz were talking about earlier was an earlier partial summary judgment that was granted to Dr. McLean. And the summary judgment altogether is the one that I think is dispositive, because the court doesn't even have to reach the partial summary judgment issue in light of the ruling on the full summary judgment that was the later of the rulings. And so at that time, because Dr. Sobel was the plaintiff's only standard of care expert, and because the record contained proof that Dr. McLean complied with the standard of care, the plaintiff was without any proof that Dr. McLean had breached the standard of care. And consequently, in a health care liability case, as the court knows, that's essential element number one, and there was no genuine issue as to any material fact pertaining to whether Dr. McLean complied with the standard of care. And that was the basis for the trial court's granting summary judgment to Dr. McLean. And of course, that was appropriately done, as the record well supports. And the order sets forth the appropriate legal standard, applies it to the facts in the record in the case, and reaches an appropriate conclusion. If I may, now I'd like to turn my attention to the plaintiff's argument about the motion to amend the answer to assert the comparative fault of the decedent. That was an issue that he discussed. All of us know well that Rule 15 of the Rules of Civil Procedure says that motions to amend should be freely granted when justice requires. I'm paraphrasing, of course, but it's a liberal standard, and it is a highly discretionary decision. In this particular circumstance, the motion to amend the answer was filed in compliance with the scheduling order. And that scheduling order had a particular deadline for moving to amend the pleadings. It was not just a deadline imposed by the court. It was a deadline set forth in a scheduling order that plaintiff's counsel drafted and to which counsel had agreed. So it is an important factor here that this motion to amend was filed as contemplated by the parties in the agreed scheduling order and following the directive of the court on when motions to amend should be filed. At the time that the motion was granted, the trial court brought up the issue of whether the plaintiff might want a continuance, given the fact that comparative fault of the decedent was now an issue in the case. And initially, the plaintiff declined a continuance and did not accept it at that time, but later did indeed move for a continuance, and the court granted that motion, so that the record demonstrates to us that the trial court actually allowed the plaintiff an opportunity to respond to the comparative fault defense pertaining to the fault of the decedent. Those ideas and those elements in the response included granting the plaintiff an 11-month continuance to address the issues that were now in the case through the amended answer, allowing the plaintiffs to get experts on the comparative fault issue, which of course is the only new issue in the case, and then allowing the plaintiff to take supplemental depositions of defense experts.
What was the point of limiting the testimony that could be offered by the plaintiff on comparative fault?
Because that was the only new issue in the case.
But I mean, even within the subcontext of comparative fault, he limited it only as to the fault of the plaintiff versus comparing the fault with the defendants or the fault of the defendants. I mean, I'm not sure that I've ever seen that happen before, limiting it to the fault of the plaintiff.
Yes, sir. And I think, Judge Goldin, the reason for that limitation is because the trial court was trying to fashion a response to the new issue in the case. And the trial court was concerned that the plaintiff might try to take this as an opportunity to backdoor in new proof on an old issue. And so the fault of Dr. McLean, the fault of the hospital, were not new issues in the case. And so the trial court granted a remedy and said, I'm going to let you address the new issue. But the new issue is comparative fault of the decedent. The fault of Dr. McLean is not a new issue. The fault of the hospital is not a new issue. Causation is not a new issue. And so on your point about comparing the fault, that's not something that experts even opine about. That's a question for the jury. The factual considerations are presented concerning what the party did or failed to do, and then, of course, causation testimony has to be presented by the plaintiff on their case and by the defense on its argument, and then the jury compares the fault. We don't disclose experts to say, in my opinion, the plaintiff's 51% at fault and the defendant's 36% at fault, and the hospital's the other percent at fault. That's a jury function. So the law wouldn't even permit that kind of testimony from an expert, and it was not really a limitation beyond what was appropriate in the case or under the law. With regard to defense experts, I would point out that the plaintiff actually took the depositions of our experts after we filed the motion to amend. So when they deposed our experts, they knew that the motion was pending. Now, I acknowledge it had not been granted, but the motion was pending. And even though the experts had been taken in that scenario, the court still said you can go back and take supplemental depositions on the comparative fault issue, which the plaintiff did not do. I mean, with the opportunity that the court afforded the plaintiff to respond to this comparative fault defense, the plaintiff did nothing. They didn't disclose an expert. They didn't retake depositions. They didn't do anything. But the important point here is the plaintiff had the opportunity to do so. And that gave the plaintiff a fair response, and the trial court was generous with the plaintiff in permitting that response. The appellant also argued just a few minutes ago this issue about replacing experts. And I'll point out in my remaining moments that the trial court, in a detailed order, appropriately considered the factors for granting such a motion from the Williams versus Baptist case from the Supreme Court, among others. And the trial court, in its sound discretion, articulated those factors and articulated the facts under each factor and determined that a replacement was not warranted. It's worth noting that the motion was filed almost a year after the problems with the relationship with Dr. Sobel began, and the motion was filed 55 days before trial. The latter fact was particularly important in the court's assessment. And there are several cases that we have cited to the court that have affirmed the denial of a motion to substitute an expert or replace an expert, even when the consequences of that ruling would result in summary judgment. We would respectfully ask that the trial court's judgment be affirmed in all regards.
Thank you.
Good morning, Your Honors.
Morning.
My name is Jim Beakes, and I'm here today representing Murray Regional Hospital in this case. We'll first state to the court that the procedural issues that ultimately led to the grant of summary judgment are essentially the same, or are the same, as to Murray Regional as they are to Dr. McLean. Mr. Phillips has obviously ably handled all of those procedural issues, from the motion to amend the complaint to the substitution of expert issue and onward. So I won't use my limited time to deal with those matters. The only matter here today that is, I guess, separate as it relates to Murray Regional is the grant of summary judgment as to Murray Regional, separate and apart from the grant of summary judgment to Dr. McLean. Similar argument to what Dr. McLean, Mr. Phillips presented for Dr. McLean. We would argue again that the summary judgment argument has been waived. A simple review of the issues presented in plaintiff's brief, the arguments, and the standard review that was set forth in the brief all suggest that the matters at issue here are to be reviewed under an abuse of discretion standard. There's no request for a de novo review of the grant of summary judgment, either on behalf of Dr. McLean or the hospital itself. So again, under Rule 27, the case law cited in the briefing, we simply would submit that the de novo review of the summary judgment motions, granting of those motions itself, has been waived. And again, even if the court were to review those summary judgment orders, granting summary judgment in favor of Murray Regional and Dr. McLean, for the same reasons that Mr. Phillips stated, we believe that the summary judgment was appropriately granted to both parties in this case, again, for many of the same reasons. The affidavits of both, the affidavits, deposition testimony, and reports of the experts were reviewed by the court. The court heard argument by both sides and issued a detailed ruling as it relates to both parties, and simply stated we believe that while it wouldn't be appropriate to review those matters under de novo review, given that they were waived, doing so would reach the conclusion again that summary judgment was appropriately granted in this case in favor of both defendants, in my case, Murray Regional Hospital. Interestingly, in my limited time remaining, plaintiff actually argues in their reply brief in this case that the only errors that led to the grant of summary judgment were these abuse of discretion errors. He again, nowhere argues that the actual findings made by the court on summary judgment were inappropriate in any way. It's simply based on the discretionary decisions that ultimately led to the court granting summary judgment. So we believe that that's really the only issue before the court today.
Thank you.
Thank you, Your Honor.
There was absolutely no reason in the world for me to redepose defense experts. The Rule 26 disclosures didn't have any criticism of Cody Blackburn. They didn't address any causation of anything Cody Blackburn did. Nowhere in their deposition did they give any opinions about Cody Blackburn. The only possible thing I could have done by going back and redeposing the defense experts was somehow open the door so now they could comment on Cody Blackburn. No reason at all to do that.
Well, let me ask you this: how were you prejudiced with regard to the limitation placed by the court on only permitting you to retain an expert to testify about the negligence of your client? Because I think Mr. Phillips is correct that ultimately the comparative fault determination is for the jury to decide.
Well, they couldn't have given percentages, but when you talk about the fault of somebody, you have to look at the circumstances, what's going on around them, and the whole
Well, presumably
picture.
you would have an expert to testify about the fault of the defendants.
Right, but when you talk about how that would have worked at trial, I could have brought in an expert, set him down, qualified him, and said, "Doctor, do you have an opinion as to whether or not Cody Blackburn was at fault?" He said, "No." Then what do? "Thank you, doctor, that's all of my questions." I mean, it raises so many questions. The jury's going to be sitting there, why would you bring in this expert and not talk about the fault of these people for this one sentence and explain? It just wouldn't have worked that way. But you can't separate new issues from old issues. The issue was fault, and there's just no way to talk about fault and comparative fault in a jury instruction we get, and it lists the factors you consider.
Would you have even needed a new expert had you had your other experts?
I believe I did. We wanted a cardiologist to talk about what was going on from a causation standpoint and the delay. But
Did this discussion happen? Did you argue this to the trial court as to what your concerns were about limiting the testimony?
Several times. We brought this issue up 4 or 5 times. We filed motions to alter or amend every time he ruled against us. We kept coming back. We kept explaining, we need this, we can't do this. And while the defendants want to lump it all together, it was really a separate issue completely. At the time all of this was going on, Dr. Sobel was still on board. He wasn't real happy about providing his tax returns, but the stay hadn't been lifted and he was still on board. We needed people to address causation and how it all worked together.
Was the cardiologist a result of the amended allegation of comparative fault?
It
Or
was.
the need for the cardiologist?
It was. That's when we decided that would be the proper witness.
So that was not, in your opinion, necessary before the pleadings were amended?
It was such a straightforward, simple case. It was just.
It was an emergency room case before, is that right?
Right, just simple. I mean, was he negligent? Did that cause injury? Now we're put in a position of having to defend somebody in addition to proving that. In preparation for today, my father asked me, should you go in and make a legal argument, or should you just argue this just wasn't right? And I guess in the old days, we did a lot more of that. I told him, it's both. It's not right. We did everything we were supposed to do. We got kicked out of court anyway. We met every deadline. It's not right, but more importantly, it flies in the face of Tennessee law and our longstanding preference of having cases decided on the merits and not some fortuitous chain of events, legal maneuvering.
Thank you. Thank you, counsel. We appreciate your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. You may call the next case, please.
Bill Charles versus